Okay, you can shake your head all you want. I'm just going to leave it there. We'll see you on Tuesday. You know, you respect me, I'll respect you, but I'm going to do it. Yeah, we're gone. We're done.
Your Honor, in regards to the probable cause conference, I spoke with the prosecutor. I believe that we're going to try and resolve this matter by seeing if Mr. Karns would qualify to get into Veterans Court. He needs to be screened at before it happened. For that reason, I'm asking that we have a new PC for May 21st.
21st? Okay, that'll be fun. Probable cause conference, I'll adjourn to May 21st, 2026.
Thank you, Your Honor. Now, on a separate matter, Your Honor, I'd like to make an oral motion regarding bond.
No, go ahead.
Your Honor, the court is well versed in this case, having spent an inordinate amount of time on it earlier this week. Mr. Karns is the first time this is his first criminal matter of any sort in his life. He's 31 years old. This has been a sobering experience for him the last 72 hours. I think that he has a greater understanding of the seriousness of the orders of this court. We're asking that the court consider releasing him at this time to home confinement, work, school, court, those types of things. If the court is inclined to give him home confinement, we would also ask that he be allowed to go to the YMCA. He tells me that the victim is not a member of the YMCA, does not belong to that YMCA. And so that would be our prayer, Your Honor.
In Ann Arbor?
Which YMCA? I think in Dexter.
In Dexter.
In Dexter.
Dexter. Responding to people.
I would not have been released on home confinement with other hours for work and school. Yeah.
All right. What I will do is I will grant defendant's request. I'll reinstate his previous bond amount. He will be released. He will have to report. Actually, I want a GPS on him prior to his release. That would be a home confinement. GPS tether with releases to school and work only, and the YMCA only.
Is that an order that I need to prepare, Your Honor?
We will prepare. I have the order reinstating his previous bond.
Great.
To the community corrections order, we'll prepare that.
Great. So I don't need to upload any.
No.
Great.
You got it.
Then, Your Honor, if I could just quickly voir dire the defendant for one quick second. What happens if the victim shows up at your house? What do you do?
I call the police.
Okay. What do you do if you see her anywhere?
Call the police.
Okay. You don't speak to her. You don't do anything. You understand?
I understand.
Okay.
You understand, sir, because of what was in this, that includes texting or any communication of any type.
Yes, Your Honor. I understand.
You understand that through no electronic means whatsoever, meaning your use of the internet or anything like that. Are you to refer to her in any way? You understand that?
Yes, Your Honor.
And you are not to try to communicate with her in any way. So understand that.
Yes, Your Honor.
You understand that also applies to your family members.
Yes, Your Honor.
And that you would be directing them not to do that.
Yes, Your Honor.
And that if the court were to find that there was that type of third-party communication, you would explain to them that your liberty is in jeopardy. You understand that, sir?
Yes, Your Honor.
Judge Simpson is giving Mr. Karns another opportunity at release, but this is not unrestricted freedom. The defense relied on his lack of criminal history, his age, and the argument that the previous 72 hours made him appreciate the seriousness of the court's orders. Judge Simpson accepted that argument only with safeguards: GPS monitoring, home confinement, and narrowly defined releases for work, school, and the YMCA. The most important detail, however, is the judge's repeated warning about contact with the alleged victim. Mr. Karns cannot avoid the no-contact order by using relatives, social media, or any other intermediary. Indirect communication can violate a bond condition just as seriously as a direct phone call or text. Judge Simpson is also eliminating ambiguity by asking specific hypothetical questions and requiring clear answers on the record. That protects the alleged victim, but it also prevents Mr. Karns from later claiming he misunderstood the order. Do you think the defense's sobering experience argument justified release, or would the earlier concerns have made you keep him detained? From this point forward, compliance, not promises, will determine whether Mr. Karns remains free.
All right. Very good.
Thank you very much, Your Honor. Thank you for your time on this matter.
No problem. Thank you, counsel.
Thank you very much.
Good morning. Joy Gaines, Senior Assistant Public representing Mr. King, who's present to my right. Would you please state your name, sir?
It's totally okay. How you doing, Mr. Simpson?
I'm doing great, Mr. King. How are you?
Good.
All right. What are we doing?
Your Honor, we do not have discovery yet as of yesterday when I met with Mr. King. Miss Sunda, I'm assuming, because I emailed her at the same time regarding his as the other clients, that we will have it. Regardless, Mr. King wants to schedule the preliminary examination. And he is very much aware of where we are in this process. He is adamant that he wants to schedule the preliminary exam.
Your Honor, at this point, I would be objecting to that, given that I have come to find out there is more discovery. There's a second venue involved in this case that does have additional video surveillance of the actual assault that occurred in this case. Further, there's going to be more discovery because I was planning to address bond today. So there will be jail calls that could be leading to other charges in relation to this case. So at this time, there are a few things in play here that I do not have yet and that defense does not have yet that I think would be very important for this case, along with another follow-up interview with the victim of this case as well.
My client still wishes to go forward with the preliminary exam as soon as possible.
Understands that if all of that's not there, or if we start the preliminary examination, that it could be adjourned if the people aren't entirely ready to go.
That's fine.
Pardon?
He said that's fine, Your Honor.
Been to jail 2 weeks. I ain't did nothing wrong. They always try to do.
Well, Miss King, let me just explain to you though. The problem's going to be you may be in there longer, sad, and nobody can go because they don't have the stuff, and your counsel can't even advise you as to what you need to do. I mean, so that's all I'm saying.
Mr. Simpson, can I say something to him?
Well, I was going to say, I know that you and I talked about that, and you understand that, and you are anxious to get this case moving forward.
Yes, I get none of these days credited. I've been in jail.
Well, sir, I don't.
No, he's on a parole hold.
Okay.
Behind.
Here's what I'm going to do. The discovery that you have now, you can get over to.
It was sent yesterday, Your Honor.
It was sent yesterday.
Currently, it was sent over yesterday. I'm awaiting further steps along with that surveillance video from where the actual assault occurred. And then potentially, and then Ms. Gaines would also get the jail calls that could be leading to future charges as well.
As to the witnesses currently charged, you would at least have police officers that could testify, correct? Because I'm going to do something with the date because everybody seems to be in a hurry. So I'm going to set an in-person preliminary examination. I'm going to set it for April 28th, 2026, a few days. Hang on. 9 a.m. That's before me.
Right. Thank you.
As to bond.
Your Honor, it's come to my attention that since being arraigned, Mr. King has been making calls to his family, that includes his sisters, I believe his mother. In these calls, he says, my son don't need to come to court, man. You don't need to come. Talk to his mama. You're right there. if you want to help your nephew, you need to get on that phone and talk to his mom. That's what I said. It's going to kill him in the end.
Not his mom.
She's supposed to be on it. I know what I would do. And further things telling them they need to talk to the victim's mother. The victim is his minor son. So he's asking them to talk to the victim's mother to try and get him to not come to court and to guilt him and to come in and testify against his father. So I suspect this could be leading to future charges of witness interfering in the future. And we've not had a chance to go through all of the jail calls. These are just a few that occurred after arraignment. And Mr. King is also on parole for a witness intimidation interfering as well.
Okay.
Your Honor, Mr. King did indicate to me that because this involves a family situation, that he had spoken to his mother and his sister. He has not spoken to his son or his son's mother, but his own mother. And everyone is aware of the allegations. He indicated that he does, to me, he indicated that he does have concerns about his son having to come in and testify and amplifying any potential issues between them. But he said to me when we were discussing that I did not have the discovery when I spoke with him yesterday, that he is prepared for his son to come and testify. So without more context, I think there may be more context than the statements alone are giving at this time.
This is the critical turning point in Mr. King's hearing. The prosecution is no longer discussing only the alleged assault. It is telling Judge Simpson that post-arrest conduct may demonstrate an attempt to influence whether the minor victim appears in court. The quoted calls allegedly direct family members to contact the child's mother, while Mr. King is already on parole for a witness intimidation or interference matter. That history does not prove a new violation, but it makes the allegation especially serious when the judge evaluates risk and bond compliance. Defense counsel takes the only responsible position available without complete recordings. She does not deny that indirect contact is prohibited, but argues that isolated statements may lack context. She also distinguishes speaking with Mr. King's own relatives from speaking directly with his son or the child's mother. The weakness is that a no-contact condition can reach communications made through third parties. If the purpose was to discourage testimony, the absence of a direct call would not necessarily solve the problem. Would hearing the entire conversations change how you interpret these remarks? That is why counsel requests context, and why Judge Simpson must avoid deciding disputed facts from fragments alone. But until those recordings are reviewed, the alleged instructions create an immediate courtroom safety concern that the defense cannot dismiss.
So the preliminary exam is April 28th. I know that you typically cease phone calls. I just want to reiterate that he has not had any phone calls with his son or his son's mother, but the exam is on
directing people to contact them. Same.
I
cannot have only direct contact, Ms. Gaines. As you know, he can't have indirect contact.
Correct. I'm not disagreeing with that. I'm just saying that based on our and terms of there may be more that we may not be getting the whole conversation in context, given how he told me the conversations with his family went.
All right. What I will do is I'm going to read the people's request. The defendant's phone privileges and texting privileges are hereby ordered revoked. Hold on, sir. Sir, do not do that.
You always take my phone. I haven't did anything wrong, Mr. Sir. I haven't did anything wrong.
Want a hearing on it? Because I'll have to listen.
Let's do a hearing today.
Want me?
Because I need to talk to my family. I have things going on.
Sir, Mr.
I want to do one today. Like you taking my phone, Mr. Simpson, and I ain't called them. The thing was, don't talk to my son. I haven't talked to him. I haven't contacted one of them.
Bond conditions were that you cannot have third-party contact or direct third-party.
I haven't.
Okay,
I haven't.
Are you going to listen to me? Because if you're not going to listen to me, then I'm not going to listen to you. Okay, you can shake your head all you want. I'm just going to leave it there. We'll see you on Tuesday. You know, you respect me, I'll respect you, but I'm going to do it. Yeah, we're gone. We're done. Court calls the case. People versus Danina Combs.
You on that?
Yeah.
That's also good people. Where we are on behalf of the Danina Combs.
Yeah, it's me.
Hello, what's your name?
Danina Combs.
Judge Simpson handled two very different bond situations in this session, and the contrast is revealing. Mr. Karns received release after the court reinstated his previous bond and imposed GPS-monitored home confinement with limited movement for work, school, and the YMCA. That decision reflects conditional trust. The judge accepted the defense's mitigation, but paired it with strict restrictions and an unmistakable prohibition against direct, electronic, or third-party contact with the alleged victim. Mr. King's position moved in the opposite direction. He wanted a prompt preliminary examination despite incomplete discovery, including anticipated surveillance footage, additional victim information, and jail calls. Judge Simpson accommodated that request by setting an in-person examination for April 28th. But the alleged jail conversations then shifted the hearing from scheduling to compliance and potential witness interference. The judge revoked Mr. King's phone and texting privileges pending further proceedings after hearing that relatives may have been encouraged to contact the minor victim's mother. Importantly, this was not a final finding that new charges had been proven. The transcript shows Judge Simpson setting the matter for Tuesday after Mr. King demanded a hearing and disputed the accusation. The immediate restriction therefore functions as risk control, while the court examines the calls more fully. Mr. King's repeated interruptions and insistence that he had not contacted the protected individuals directly also missed the judge's central point. Indirect contact was prohibited. Was revoking all phone access appropriately cautious, or should the complete recordings have been reviewed first? The broader lesson is simple. Bond conditions govern intermediaries as well as defendants, and courtroom frustration cannot replace a focused legal objection. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.